Ciao a tutti, this is Prof Jo at Prof Jo Explains and Surviving the Survivor, and I think Joe will be on shortly. We're supposed to start today with the memos that were provided by the defense at 6 p.m. last night, and then the state in response and the judge's review of it. But the judge sent the two sides, I believe, an email later yesterday. I think he looked at some cases and he said he now needed both sides to focus on the prior consistent statements made before any pressure was put on Carmen Lauber to change her story and to say that she got illicit, I guess, street drugs for Kouri Richins. And then there was a series, I believe, of more emails. The state then said it would only put in two documents or two edits from the recording. And we don't know where we're going to be this morning. My only prediction is I thought yesterday that the judge's schedule with the defense submitting at 6 p.m. in writing, and then the state responding, and then the judge looking at it, the judge ruling at 9:30, I think today, Utah time, and then the videographer would make the cuts to the long video, and meanwhile we would start with the testimony of the lead detective, O'Driscoll. I really thought that was not a likely schedule, being a person half empty, always with my glass, and also from having watched what's gone on before. And now with this new wrinkle, let's say, in what's occurred, I think it is less likely that this schedule is going to be adhered to. But we will see. This kind of thing should not happen in the middle of the trial after the jury is sworn in and paneled. It is really not the way things should proceed. The fact that apparently the case law in Utah says prior consistent statements, you need to identify that they were made before there was any push by or pressure applied or any reason for a change in a story. I don't know why the defense and the state didn't uncover this law sooner. It's out there, and if it's really that clear, it should have been found by both sides. In particular, the prosecutor, since the prosecutor then moved after the testimony by Kouri Wright to say it wanted to put in prior consistent statements. It should have looked at this. Now, if you don't recall, what happened was Kouri Wright was on the stand. He had said he didn't know that he knew of I think Eric. I'm not even, maybe high school drugs. I'm not even sure he said that, but on the defense cross, I know what it was. The prosecutor said, have you ever seen Eric take drugs? Kouri Wright said no. The defense lawyer on cross got up and said, well, you said you didn't see them. Had you ever heard of him taking drugs, taking anything? And then Kouri Wright said he had heard he was taking drugs generally. And then the defense said, well, now we're entitled to impeach based on what he said at a preliminary hearing where he said he didn't know of Eric taking illicit drugs. And then what happened was she said, do you know I'm taking drugs? And he said, yes, he had been told that. Then the prosecutor wanted to introduce prior consistent statements where he had continued to say that Kouri Wright he knew nothing of Eric Richins ever taking illicit street drugs. And that's when they got into the big fight about, does he know what an illicit street drug is? Was the question from the prosecutor, illicit street drugs, was that particular to street drugs, or as the defense argued, does that mean if he was taking somebody's prescription pills that weren't his? Aren't those illicit drugs? And they went on and on and on about it. The judge ruled on a couple of things, and then he told both sides, well, he told the defense, go back through the videos and point out any inconsistent statement or where you need to enhance the video, what the video recordings are that the jury will hear, because out of context, you need more context to do it. And point out where you think the statement should not come in because it's not prior consistent. That's where it was left. The defense was supposed to come back with a written statement at 6 last night, but before the defense did that, the judge did this research and discovered that the law is, or seems to be, that the consistent statements to rehabilitate the witness on the stand, the consistent statements have to be before the event or the pressure or the whatever it was that brought the new statement. That is, I didn't know that he ever, that he ever took drugs. And so there was, both sides then were supposed to look at the timing and see when the statements were made. That obviously upsets the apple cart with regard to telling the defense you have to have your written statement in by 6. I don't know whether the defense still filed a written statement at 6, but we're going to hear all that today. The judge was on the stand, and now we just, or not on the stand, on the bench, and now we just see the seal of the state of Utah. And I don't know whether he's sitting down there, because when he's sitting, I don't think we can see him. I don't know when he went off the bench. I don't know whether they're at sidebar. I don't know whether they're out in the lobby doing a tarantella or, dancing a waltz. I don't know what's going on, except I'm here and I see nothing from them. So that's my summary of where we are. And if you would like more, so would I, but unfortunately, we're not getting it until the judge gets on the stand. But it is clear. It is clear that
this is 231-500-139, State of Utah versus Kouri Richins. Counsel for the state are
that
present.
Is my
Counsel
comment.
for defendant are present, as is defendant Kouri Richins. Let me just provide a summary of how we got from yesterday to today.
Okay.
At the close of proceedings yesterday, we had a plan to receive defendant's written response to state's motion to admit redacted exhibits 8-57R through 8-63R as prior consistent statements under Rule of Evidence 801D1B. After everybody left the courthouse and upon reflection, the court did some additional research regarding the foundational requirements of 801D1B, issued a ruling requesting additional foundation for admission of those redacted exhibits under that rule. That's docket 1700-1700. And shortly after that, had a WebEx conference on the record with counsel to discuss the court's concerns regarding the foundation requirements for that rule. Following that, the state narrowed its request to seek, as I understand it, Mr. Bloodworth, publishing, not admission, of portions of only 2 of the proffered exhibits. That would be 5-58R and 8-62R under Rule 106. Is that correct?
Yes, Your Honor.
Okay. After that, counsel, to their credit, engaged in a productive email exchange regarding their positions regarding those redactions. I think we need to discuss those one at a time now. Is that your view, Mr. Bloodworth?
It is, Your Honor.
Ms. Lewis?
Yes, Your Honor.
Okay. It would help me to just go through these one at a time and talk about what's happening here. So let's start with Exhibit 5-58R, which is the transcript of a May 2nd, 2023 interview of Carmen Lauber. And we begin as I understand it, and I'm going off the eight 58R. Did I misspeak? My apologies. 8-58R. Thank you for the clarification. I want to make sure I'm looking at the right email here. Not. My apologies. I need to print the state's response. One moment.
Your Honor, it's probably the 8:05
Kind
p.m.
of cute.
Yes, that's right.
He should have a law clerk that he could hand it off to and say, print. I don't know why he has to do his own. Or even a legal secretary. Peculiar that he's doing his own printing.
So, forgive me, Mr. Bloodworth, in response to the state's highlights in and around page 75, like 1921, the defendant states, quote, "This completely resolves this proffered section, leaving nothing for the court to decide." But then the state, I think, sees it a little differently. Help me understand here.
Yes, Your Honor. The highlighted, I think for the purpose of this discussion, the highlights are immaterial. The highlights related to the 801 discussion.
Okay.
So in the 805 email last night, the state set forth its view by page and line number of the 106 arguments.
Okay, so the state's position is that page 65, line 4, through page 87, line 13, from this should be published under Rule 106.
That's correct, and that section of that statement, that section of the transcript applies to both the first and second paragraphs. It encompasses both of the statements that
Melody Cobby, you said
both
you
of
felt related to
defense's statements
Carmen's
that are
intervention.
outlined in
Right.
paragraphs
What do you
1
mean?
and 2 of the 805 email.
Understood. And so to the extent when we look at 8-58R, to the extent that between page 65, line 4 and page 87, line 13, there are some sections that are not currently highlighted, is the state's position that those are included in the state's request?
Yes, Your Honor, I think for purpose of this discussion, we can ignore highlighting.
Okay, got it. Let me pause there. Ms. Lewis, take a moment. Take the time you need.
It was Carmen, you're right, it was Carmen's testimony that they needed to go back through and look at, and the subsidiary issue was whether they could get that in through Cody Wright without having to recall Carmen. So you're exactly right. Thank you, Melody Chavez. I said Cave, I missed the Z the first time, Chavez. I'm just really, I think the judge is probably unhappy also. I'm sure the lawyers are unhappy. But if the law is out there and clear for neither side, and this time it's I think really the state, because the state wanted to use the prior consistent statements to rehabilitate. It's really the state that should have.
I didn't realize we were ignoring the highlights until right now. So,
Well, I think if it helps speed things along, as I understand it, the defendant didn't have any trouble with the highlighted portions. It's now the unhighlighted portions between 65 and 87 that we need to make sure you get an opportunity to respond to.
actually, Your Honor, we had agreed to letting in all of the highlighted portion on page 75 and 76. because that would be what was related to the statement that I elicited on cross. So that's what we had agreed to, which is what we believed the state wanted, because, like I said, it wasn't until Mr. Bloodworth just said we were now ignoring highlights. So we agreed to page 75, line 8, starting at line 8, through page 76, ending at line 5, under the rule of completeness, because that completed the discussion around the elicited statement, which is give us the details that will ensure Kouri gets convicted of murder. I think going all the way back and adding in everything does not have to do with that statement. It's a lot of discussion. I mean, it doesn't have anything to do with O'Driscoll's statement that was elicited through Carmen. It's talking about, I'm trying to look at the unhighlighted parts now. I mean, it is talking about that it's about she doesn't know the situation between Eric and Kouri, which wouldn't have anything to do with that. It's about when we're going to meet again. She says, I need to go through whatever I need to go through to figure out. I mean, this doesn't have anything to do with that statement by Detective O'Driscoll. I mean, I agree the stuff right before that and immediately after that that completes that line of question and answers should come in. But, for example, on page 67, Detective Maynard says, I'm just saying we're going to need you to settle down and get details and timelines. I mean, that doesn't have anything to do with the statement. And it's also hearsay by Detective Maynard.
This is so difficult.
I suppose if Mr. Bloodworth wants to question Detective O'Driscoll about some of these other statements, that would be appropriate, but I disagree that all of this comes in under the rule of completeness.
I think we need to be a little bit careful here. It's not Detective O'Driscoll's statements that are subject to the rule of completeness. It is Ms. Lauber's statements that are potentially subject to the rule of completeness. And as I understood the state's position, it was the context provided by Detective O'Driscoll's statement on page 75 combined with Ms. Lauber's response on page 82. And that was, as I understood from back when Carmen Lauber testified in open court, what the state believed they needed to correct the arc of. Is that fairly stated, Mr. Bloodworth?
It is, Your Honor, and I can provide additional detail to the extent we need it.
If you would just make a record for why the state believes page 65, line 4, through page 87, line 13, is required to explain, qualify, or provide context for Ms. Lauber's testimony, I'd appreciate it.
Your Honor, the necessary context is that Carmen Lauber was agitated about her involvement in Eric Richins' death, and that detectives were trying to settle her down and focus her in on the details. The court can see the word details in this portion of the transcript appears a dozen or so times as Carmen Lauber is scattered. They're trying to just get her focused in on the details, and in the details and explaining to her, right, because the broader context here is they're talking about her immunity, and they're explaining to her that details are necessary so that they can corroborate them, and that corroboration of those details is necessary for immunity. That is the context of the statement.
Ms. Lewis, go from there, please.
It's difficult to follow this when we can't see the
Sorry,
documents. So frustrating to me. I'm sure it's frustrating to you too, but it's really frustrating to me.
Your Honor, if the state could add, that is the narrowly tailored context of the statement. The state, water under the bridge, but the state has argued the entire series of interviews provides that context as well.
That's been preserved.
It has. I appreciate that.
The state initially wanted everything, then it got it down to what did they say, 90 or 100 pages? That's what they were arguing about yesterday before we started into the weeds and having more and more trouble. And I saw a comment that Ms. Lewis was not prepared. She was trying to read that document that the state provided, I don't know what time last night, about this is all we want now. She's trying to scan it to see if she needs something before or after for completeness, or there's more in it that needs to be. And you've got to give her some grace here. I mean, they've been racing around trying to do this since court adjourned yesterday. They were in the middle of doing one document when they got the email from the judge. Then they had to go back and try to do it again. Then they had that meeting.
What they're saying. I don't disagree that all of that is necessary under the rule of completeness.
There you go.
I would just stand by our objection that really what should come in is the complete statement on page 75 and 76. I will say, in looking at this though, I was already, when we were looking at it previously, just the highlighted, I really didn't have a problem with
Thank you, Erin.
through line on page 82 through line 17 on page 82, because I actually do think some of that came in during cross. I'm not, probably like to take out the stuff between, well,
Editing
No, that's
on
okay,
the
never
fly is dangerous.
so I
Dangerous.
really don't have a problem with line 8, starting with line 8 on 75, through line 17. Although, I'm sorry, Your Honor, this skips. I mean, we go from 76 to 82, so
No, with the state's request, and I can appreciate why you just need a moment to walk through it. But sitting here this morning, the state's request under Rule 106 is to publish, among other portions, page 65, line 4 through page 87, line 13 of this.
So you also want, which you did include, 77 through.
I see.
So there's a gap in what we're looking at pages 77 through 82.
Is there?
Yes. What they've provided that they wanted jumped from page 76 to 82.
I'm so sorry, Mr. Bloodworth. I'm reading your email of 8:05 p.m. 65, line 4 through 87, 13 inclusive?
Correct.
Okay.
That is correct. I think that the disconnect here is the pages we're looking at. or
Jump.
She's looking at jump, yes.
Oh, okay.
I see
So now
Keisha
you
saying,
want the pages you both have here also.
I did not appreciate that. I've got to see the other pages.
the defense is always like this. I agree with you, but this time they've got a
Yeah, my
reason.
apologies.
I think, here's what we'll do. Page 65, line 4, through page 87, line 13.
87? 13?
This is
Minus
not the way to
pages
do it.
77 through 81.
Gotta look at-
Okay. So now we're back to
We're
the
back.
proposed
This will
spot
take
at
us
58R.
here just in a more efficient way.
Yeah, that's fine. Okay, so Ms. Lewis, my apologies. Now I think we're all on the same page regarding the paper version of 5, I keep doing that, 8-58R that we're looking at. Thank you for raising that. So just so the record is clear, we're currently contemplating page 65, line 4 through 7625, and then 82.1 through 87.13.
I would agree with 76, starting at line 8, through the bottom, I'm sorry, 75, starting at line 8, through the bottom of 76, and I am all right with page 82 through line 17. But we would
Teach
object to the rest.
4:30,
Okay.
that comment
Bear with
amuses me. It's not just time, it's jury time in terms of having to listen and whether they'll be able to pay attention through all of it. That's really, and whether other things that will come in that they shouldn't hear that are in those 7 hours. That's what, in a part, they were trying to do by the edited version. And then the defense was going to look at the edited version and decide, should more come out, should some come in? I don't know what's in the full 7.5 hours, but there may well be comments such as,
All
or
right,
you know, Kouri was stealing
The
money.
court is persuaded that the statements of Carmen Lauber elicited on cross-examination, as indicated on proposed exhibit 8-58R on pages 75, line 19 through 22, 82, lines 8 through 11, and page 86, lines 17 through 19, require, under Rule of 106, context, qualification, and explanation in the form of additional portions of 8-58R. And those additional portions are page 65, line 4, through page 76, line 25, and page 82, line 1, through page 87.13. Any clarification, Mr. Bloodworth?
No, Your Honor.
Okay. Ms. Lewis?
No.
All right.
No.
So I think that handles bulleted or numbered paragraphs 1 and 2 in the email exchange between counsel, correct, Mr. Bloodworth?
Yes, sir.
Okay. That brings us to numbered paragraph number 3. Bear with me.
I hate the way they're doing this because when you edit on the fly, no matter how careful you try to be, errors happen. You need to be able to sit down, edit, think about it, look at it, ponder, look at it. And I think Kissis had said again, it's Carmen's statement.
So
they're
here,
talking about.
to
And she's
provide
right.
additional context, qualification, and explanation for Ms. Lauber's statement that I get that related to the get out of jail free card, Mr. Bloodworth. I understand the state is requesting publishing 114 line 6 through 115 line 6. Is that right?
Correct, Your Honor.
Okay. Ms. Lewis, go ahead.
Your Honor, I think the discussion about what Ms. Richins is doing, about the children and the relationship with their father, all of that doesn't add any context to what Detective Maynard's statement is. I mean, I guess I'm not opposed to going through line 12 where she says, oh, I get that. But the rest of it it's also quite prejudicial.
Why is it prejudicial? I mean,
Well-
it doesn't matter if it's prejudicial. I don't have any discretion here if it's required for.
I understand. But
So,
I mean, the fact that he says you're on what your get out of jail free card looks like based on the information that, and then he says there's 3 little boys that don't have a dad, there's a family that doesn't have a brother. I mean, what does her response about the boys and Eric have anything to do with the fact that she now has a get out of jail free card if she gives them her information?
I understand the state's position to be this shows what her motivation, the complete version of her motivation, rather than just a motivation to serve her own interests. Is that about right, Mr. Bloodworth?
That is, Your Honor, and Detective Maynard couples the two in his statement. It's get out of
I know he
jail free
froze.
card looks like, based on the information, that there's 3 little boys that don't have a dad. He's coupled them.
I'm sorry, can you finish?
Yeah.
I don't know why just going through line 12 where Ms. Lauber says, oh, I get that. Why doesn't that complete that she gets that that's why it is because of this reason? Why do we have to go into
Now they're having a conference
the
rather
rest
than
of
a,
the relationship
argument
with
with
her
the judge.
kids and that Kouri's living her life while everybody else is suffering? I don't understand how that completes anything
Thank
more
you,
than just
Farewell.
ending with Ms. Lauber's statement at line 12, that she understands that's why it is, because of the circumstances.
Mr. Bloodworth? Go ahead, sir.
Your Honor, it completes Carmen Lauber's expression of her motivation to cooperate.
Okay. Having considered the arguments of counsel and looked at Carmen Lauber's statement on page 114, line 12, the court is persuaded that under Rule 106, publishing of page 114, line 6 through page 115, line 6 is necessary to explain, qualify, and provide context for her response. All right. That brings us to pages 182 and 183, correct, counsel?
Yes, sir.
Okay. So here, the statement that the state seeks to provide additional context, explanation, and qualification for is Ms. Lauber's statement on page 183, line 5. Can you guys just write it and I sign it? Correct, Mr. Bloodworth?
Correct, Your Honor.
And the state's position is that under Rule 106, we're required to go back to 182, line 12, and include through 183, line 14. Do I have your position correctly?
You do, Your Honor, and that necessary context is that the detectives needed Carmen Lauber to put her verbal statements on paper and that detectives were not able to do it for her.
oral statement, not verbal.
Actually, I'm fine with that. I think there was a typo in what we said in our response.
Okay. Very good. The court is.
lines.
Oh, I'm sorry to cut you off, Ms. Lewis. Go ahead.
No, I'm sorry. I was just saying in terms of the lines we agreed to, I think that's just typed incorrectly. That's not a problem.
Okay. Under Rule 106, the state is permitted to publish line 182, page 182, line 12 through 183, line 14 from 8-58R.
So that was Carmen, you remember, said, guys, write it and I'll sign it. And the state said, but that relates to her agreeing orally or telling them orally what happened. And now she says, you write it for me. And you need the earlier to see
Anything
that
else from
just write it and I'll sign it.
8-58R, Mr. Bloodworth?
No, Your Honor.
Okay. Ms. Lewis.
For the information.
All right.
They're just what
That brings
and
us to
anything.
8-62R, correct?
Yes, sir.
All right.
It just means she's told them everything and now she wants them to write it
We go to
down.
page 12.
And you can see how that provides context.
Here, in response to a question from Detective Maynard, the goal is to convict Kouri for an aggravated murder. These parallel drug investigations, those aren't a priority. Ms. Lauber says, right. And the state asserts that completeness requires that we also publish page 11, line 20, through page 13, line 22, correct?
Correct, Your Honor. And the necessary context there is that Carmen Lauber is spooked by the federal grand jury investigation, and Detective Maynard is assuring her that that federal grand jury investigation is secondary to the murder investigation.
Here's another one where they're arguing context, but the one before, I think, should make clear to you what they mean by arguing context, because guys, you write it and I'll sign it. It could be read to me and she's going to sign anything they want her to sign. In the earlier,
Yeah, I really think that if we start at page 11, line 20, and go through 12, line 20, that it states enough to cover all of that without getting into the grand jury, which is a whole other can of worms.
Why can't we go to 13, line 7? It gets a little confusing after that, I'll grant you, but 13, line 7, I think, is an important closure on that issue of the potential for federal charges.
I'd like to take out the reference to the grand jury. What if we,
Help me understand, what is it you think is a problem with the grand jury? This is what they're talking about, is federal charges.
well, they are, but it's clear in here that she's saying federal charges are the next, that's more up the chain serious, like the highest extreme. So it's already in here that they're already saying that federal charges are more serious, and he's telling her not to worry about that without getting into the grand jury, which causes me concerns. Gives,
but you didn't
I
answer
mean, that's something
why.
we've avoided talking about. It speculates that it's going to allow the jury to speculate about what that means if there's other charges. I think most people don't know what a grand jury is. They may think there's another jury that's made some kind of finding. I mean, we maybe could go through line 7 if we just take out, we could even just take out on 13, starting at line 2, just take out that's where it's formalizing it with the grand jury.
Let's talk about mechanics for a second, Mr. Bloodworth. I understand, or I appreciate that these are many fewer pages of transcript than was under contemplation yesterday. Are we just going to show the transcript to the jury at this point, or have we cut the video down?
Your Honor, we've set the conditions where we can cut the video down. There's still a little bit of editing time, but not much.
Sure.
The state intends to publish by, as we've published other similar exhibits, playing the video with the transcript rolling beneath it.
Okay. All right. I appreciate that. Okay. Mr. Bloodworth, talk to me. Why, in the state's view, do we need to go beyond line 7 on page 13?
Sorry to interrupt, but I'm actually okay if we go through line 10.
Okay. Line 10
That
on page
completes the
13.
thought.
Now you're seeing what lawyers do, but this should be done at a table, each side doing, and then talking to each other, and then you get a clean copy and look at it, because when you edit and you don't have a clean copy, you don't necessarily get a good sense of
That's
how
agreeable, Your Honor.
All right.
what it's.
So, first, the court is persuaded that, with respect to state's proposed Exhibit 8-62R, publishing page 11, line 20, through page 13, line 10, is necessary under Rule 106 to provide additional context for Ms. Lauber's response to Detective Maynard's question as depicted on page 12, lines 2 through 6. The court is not persuaded that a stray reference to Carmen Lauber appearing before a grand jury will mislead or confuse the jury in any way about any consequences or any investigation regarding Kouri Richins. The defendant's request for redaction of that sentence is respectfully denied.
See, those of you who say
Anything further on that, Mr. Blood?
notice,
No,
he
Your Honor.
makes the decisions, and that one went
Ms.
against
Lewis.
the defense
No,
again.
Okay. Scott, do you need any of those numbers again?
No, Your Honor, I was following along and I have them down, and I can, provide a copy of the videos as soon as I have them ready to the defense, to have the process you'd like.
Perfect. I like that plan. Let me just write this one down. Mr. Bloodworth, that means the remainder of State's motion to admit redacted exhibits 8-57R through 8-63R is moot at the current time. Is that correct?
That is correct, Your Honor.
Okay. Got it.
And now they're going to hear much less, which of course I think makes sense. I don't know how many minutes
Okay.
this will turn out to be, but they will hear and see the transcript. The exhibit.
Counsel, last evening I sent out notice of the court's decision denying defendant's motion for mistrial. I'll issue a written ruling providing the court's analysis in the due course, but I needed to make sure that you had notice of that decision. I also gave notice of the court's designing a remedy under Rule 16 of requiring the state to recall Ms. Lauber in its case in chief to make sure that defendant has an opportunity to cross-examine Ms. Lauber about the alleged violation of her drug court probation in November 2023. I know only 12 hours have transpired since that time, Mr. Bloodworth, but what is the state's expectation?
Your Honor, she will be here at 1 o'clock.
All right. Are we starting with her?
Yes, sir.
Okay. Ms. Lewis, anything further on that?
I imagine nobody will be discussing with her what she's coming back to testify regarding between.
Well, I told her she was still subject to the subpoena, that she was not released. I'm sure all officers of the court will abide by the rules there. You'd be within your rights to ask her if she's talked to anybody in
Sure.
the meantime.
Sure.
I imagine the state will have some limited redirect of her upon putting her on the stand.
Yes, Your Honor. Maybe we can clarify just scope
Sure.
of cross. I think the record's clear in the state's papers that defense has already had an opportunity to examine her on this issue. I appreciate the prophylactic nature of the court's ruling.
Right.
I'm happy to protect the record. But as I understand it, the scope of defense's cross-examination of Ms. Lauber today is limited to impeachment based on the materials surrounding her supervision.
Yeah, even, I think more specifically, the material received by the defense pursuant to the subpoena that allegedly revealed this potential violation of her drug court probation in November of 2023. That's the new information.
Okay, and as I understand, that new information is an unsigned affidavit, although substantively that affidavit is no different than the information provided pre-trial.
Yeah, that was a little unclear from the papers as to whether the subpoena response gave more detail than what was provided pre-trial. I honestly don't know.
Yeah.
And I want to be clear, this will come out in the court's oral ruling.
Sure.
The court is not making any finding that the Summit County Attorney's Office intentionally withheld any information, but the knowledge of Detective Maynard is imputed to the state, and so we are where we are.
Your Honor, I appreciate all that. I think the only information in the subpoena return that was new was a printout of a link to a drug test result, the link which has long expired. So,
Was the unsigned declaration provided prior to trial?
Your Honor, it was not, but all the substance
I see.
in that unsigned declaration was provided prior to
Okay.
trial.
Well, to prevent any
Sure.
infirmity on appeal, my view is that the scope of this recross that the court is providing the defense an opportunity to do are the facts and circumstances related to any potential violation of Ms. Lauber's drug court terms and conditions in November of 2023.
Understand.
Ms. Lewis.
Just some clarification. Well, first, the only information we had before was that she apparently had drank alcohol. The information about the circumstances surrounding that is new. But the other thing, so I included in what the state sent us was the letter that Carmen Lauber sent to Judge Mabee, which I did have before, but I didn't question her about it. But now I would like to point out that what she says in that letter is not accurate.
What's the date of the letter?
February 15th of 2024, where she says that she's been in 100% full compliance. Well, now we know that she's not been in 100% full compliance, so.
I don't know if we know that. We know that she was observed holding an alcoholic drink. We don't know if she ever consumed it. So, I mean, I suppose if you want to ask her if she violated her condition of not possessing or purchasing alcohol, you can ask her that. But,
Your Honor, I'm not sure that's,
No, it says she was consuming it here.
well, that's an unsigned affidavit. We got to be careful. That's not evidence of anything. It's just words on a piece of paper. You can ask her about it, but we can't admit that. Go ahead, Mr. Bloodworth.
Your Honor, the letter to Judge Mabee, I believe, has been in discovery for years.
No, and Ms. Lewis is not suggesting otherwise. It's just she's not suggesting now she has, in her view, evidence that the statements made by Ms. Lauber in the letter are not true. And so she now has a reason to ask her about that.
Understand.
And then we were provided also this, I guess it's a screenshot of text between Ms. Lauber and Detective Maynard that we just got also for the first time that I didn't have. So I would like to ask her again about her communications and her supervision.
As long as you're within the dates of those text messages. Unless they had those as well. I don't know.
I mean,
Your Honor, they don't, but she testified to exactly what the text messages show, so I don't know if there's any impeachment there.
And is that true?
She testified that, off of my memory,
Yeah.
she testified that her check-ins with Detective Maynard amounted to one of them texting Lauber, the other responding with Maynard, which is precisely what the texts show. So in fact, I think the text messages are 100% entirely consistent with Carmen Lauber's testimony.
Ms. Lewis, let me look at the text with you for a moment. My apologies.
that's fine. I would need to look at that portion of the testimony again, because maybe my recollection is incorrect, but I know she also testified about a lot of communications with Detective Maynard. I mean, I think it would be appropriate to ask her if these communications were in text, because the texts don't include that. And I don't know why we have just a screenshot of a week of text. I mean, this is incomplete.
Well, but Ms. Lauber's not going to know why that's what you received from the subpoena response. You can ask Detective Maynard about that if you want to call him.
She doesn't want to call him.
About why we only have these dates. Is that what you're talking about?
Right. Ms. Lauber won't know why Detective Maynard or the Summit County Sheriff's Office did or didn't
right.
produce
I wasn't
additional
gonna-
records.
I wasn't going to ask her that. I was talking about if this is a fair representation of all of her texts. I mean, I was.
All of her texts for Saturday, February 14 through Monday, February 16.
Well, Well, I think I could ask her if this was a representation of her text throughout her supervision, if this is what they did.
There's no. What's the foundation for the fact that they only texted for 3 days in February of 2024?
No, what I'm saying is, I think I can ask her, show her this and say, are these 3 days a representation? Is this how you always communicated with him? Not just these 3 days. Does this represent how you always communicated with him?
I'll give you a limited latitude there.
Okay. And then,
I want to make sure you heard the word limited when I said that.
and then I need to look
acknowledge
at
it.
exactly what she said about that before, but I may have some other questions regarding how they communicated other than these texts.
Okay. Take a look at it. Let me know if you want to readdress this prior to 1 p.m.
All right. Let me just make sure that's everything.
Now, to be clear, my view is that because we're in the state's case in chief and we're recalling one of the state's witnesses, Mr. Bloodworth, if you want on direct to direct examine Ms. Lauber regarding the November 2023 events, if any, you're permitted to do so.
Yes, sir.
Okay.
All right, I think that's it.
Okay. Let me pause there. Anything else on the record at this time, Mr. Bloodworth?
No, Your Honor.
Am I correct that the state's intention, as we sit here at the moment, is to call Ms. Lauber and Detective O'Driscoll today?
Correct.
Okay. Do you have any intention, as you sit here at the moment, to call any other witnesses in the state's case in chief?
No, sir.
Okay. Understanding we may or may not get Detective O'Driscoll done today, but certainly will sometime tomorrow. Does the defense, if it plans to put on witnesses, that's your prerogative to choose whether or not to do so, have a couple or more in the wings for tomorrow?
We do.
Okay, very good.
So the defense is
Anything
going
else
to
on
put
the
on
record
the
right
case.
now, Mr. Bloodworth?
No, Your Honor.
Ms.
Def-
Nestor?
We'll definitely want to need to take a break after they rest to do our Rule 17 motion.
Fine.
That's
And we
probably-
also, while we're talking about scheduling, we've got plenty of time here. We would like to build in a little bit of time to have a conversation with our client upon their arresting. There are some decisions the client will need to make. And we may need
Justifies.
about 30 minutes to do that.
No problem. No problem at all. Okay.
Got to talk to her about
Anything
what
else
she
on the
wants.
record at this time, Ms.
Fair.
Nestor?
No, sir.
All right, folks, we will be in recess. Why don't we plan counsel to be back at 12:45, just to make sure we handle any issues that may come up between now and 1 p.m. All right, we'll be in recess until 12:45. Thank you.
Thank you.
All right.
So that Rule
course, the
17
recess.
motion that she referred to, Nestor, I'm guessing is their motion for a directed verdict saying there is insufficient evidence from the state to prove the case beyond a reasonable doubt. And I think they're going to go on whether there's sufficient evidence to prove that she administered the drugs, the fentanyl that killed Eric. So that's where we are. There was a comment in the chat that I saw from Clo 5243 saying the defense is interested in winning, not justice. Well, what the defense is interested in is making sure that it puts the state to its proofs. This defense is not obligated to do anything. The state is obligated to prove its case beyond a reasonable doubt, and it's supposed to use only admissible, relevant evidence, and that's what the defense is doing. The defense's job is not to provide justice for the victim or justice for the criminal justice system writ large. Its obligation, its only obligation, is to make sure that the defendant gets a fair trial. So I will take any questions if there are any. Otherwise, we're not back until 2:30, right? 2:45, 2:45.
2:45 Eastern Time. Hi, Joe. How are you? Just want
Hi.
to let everyone know that because it's such a long recess, we are going to end this stream and we're going to allow everyone to take a few hours and hold on, Joel, take a few hours, and we're going to create another stream. It'll be obvious, and that will be going live at 2:45 Eastern time. So after you finish with questions, we'll end this stream, and then we'll have a new stream.
Okay, and that's the COE in case anyone didn't recognize her voice from Surviving the Survivor. Are there any questions in the chat that you see that you want me to try to address before we go off? I think she went off, so she didn't hear me. Okay, will the walk the dog let her come and throw a disco? I believe so, yes. Is this, of any of this highly unusual hearing grounds for appeal? Yes. Well, partly it's grounds for appeal because of the context and the dimensions of their arguments that they're making about whether whether the state is entitled to rehabilitate Carmen Lauber through a different witness, that is O'Driscoll. The judge says there's no law that says no, and he thinks it's clear. The defense thinks it's clear. You shouldn't be able to do it. So that's part of the underlying issue here. There may well be grounds for appeal from the defense on how this came about. So in general, that can happen. But in terms of the hearing itself, not the fact that they actually had to have this hearing in the middle of the trial. It's unusual, but it happens. But what I've been saying repeatedly and probably ad nauseum is that when you do things on the fly, you're editing on the fly, you're doing things quickly, errors happen. And so this hearing at least raises the possibility that there's going to be something that was overlooked, done improperly. The defense may say we had to rush so much that we missed this and then we didn't get a chance to fix it. So it does increase the possibility of those sorts of claims. Okay, Tara Wells wants to know why they need to meet with their client for 30 minutes. I'm assuming they want to discuss with her whether she takes the stand or not. I don't know that for a fact, but that's the one I think is the most likely. And I think they want to give sufficient time to run through with her. Okay, here's where the case is right now. Here's what we think is the likelihood or whether we can win, we can prevail on a reasonable doubt case, particularly with regard to the fact that they can't prove you administered the drug. So they're going to want to run through that with her so she can see where they think the strength of the case is without her getting on the stand. And that will take at least a few minutes. And then they want to talk to her about what would happen if she takes the stand. And they may want to try to do a few little questions with her to see how she would answer and for her to recognize what pitfalls there are for her. Now, if that question anticipates, and I assume it does, that they've already been talking about this before the trial starts and maybe throughout the trial, you're right. But they want to nail it and be clear with her before they start the defense case. Now, they can change their mind during it, but whether she testifies or not probably will affect what they do and how they do it in terms of presentation of witnesses and other things on the defense side. So they want to have a pretty clear view that she's settled. And I'm pretty sure, actually, I would say very sure, they do not want her to take the stand. Okay. Is the defense trying to impeach Carmen? Well, they did try to impeach Carmen based on, the statements such in the original, that what they asked her about, you guys write it and I'll sign it. That's trying to impeach her credibility when she says she made her own independent decision and this is really what happened. And sure, that's what any opposing counsel is trying to do to the witness for the other side, impeach or at least crawl under question or provide context, lessen the impact of the testimony. And so the defense tried to do that. What's happening now is the state says it has the right to bring in prior consistent statements to rehabilitate after the defense makes the claim that the statements were not correct, fraudulent, and they were created after some event, such as the law enforcement threatening her or her getting a deal. Okay, scrambled eggs. If the defense appeals on the basis of being rushed, won't the record show that they just weren't adequately prepared? Well, this particular issue that came up, you got to keep them separate. This one, the rushed part for me would be after the judge looked at the law more carefully and decided that they needed to point out things that happened before what she said before law enforcement made any sort of statements that might be perceived to be threatening or offering a deal. Rushed isn't enough because the defense is agreeing. They could object and say, we need more time, make it clear on the record. I think they have. And the context of this coming up in the middle of a trial, of course, it's not going to be given the same time it would be if this was 3 months out or even 3 days out, because you've got the jury sitting. Can the state question Kouri? I assume not. If she gets on the stand, the state absolutely can question Kouri. That's why the defense is going to argue strenuously to her, don't take the stand. Okay, well, they've had, 3 years to prepare seems pointless. Well, you can have 3 years to prepare, and there are a lot of documents in this case. Think about all the hours of interviews and all the emails and all the text messages. But you make your arguments to the judge pre-trial, you win some, you lose some, and then you have to reconfigure how you're going to do it. That's true of both sides. And it's a moving target because the defense makes some arguments the judge may agree in part. And then the state may come back and say, well, if I can't do it this way, can I do it this way? So it's a moving target over the time. Okay. Why does she have so many attorneys? Daybell had one, and that was death penalty case. That I cannot answer. That's out of the realm of what I know. Okay. Chili Dog 165. Oh, that's the question I just answered. Sorry. Any other questions here? I see one. Do we think the same defense attorney will question Carmen this time? Yes, I do. The lawyers are, they divide up the case. I'll handle witnesses A, B, D, E. I'll handle all the forensic, telephone or GPS information and phone information. I'll do the financial information that's going to come in, and they don't switch. They don't switch then, because you're going to have lawyers who are very well prepared on the areas of the case that they had prime responsibility for. So they're going to do it. Okay. Anything else before we break for this long break? Okay. Do I think the prosecution has enough evidence to withstand a motion for a directed verdict? Yes, I do. Because the motion for directed verdict, this is coming from Butterfly Me Away. The motion for directed verdict is giving all the evidence that the state presented in the light most favorable to the state, drawing all inferences in a way that is favorable to the state. Did the state prove the case beyond a reasonable doubt? And I think the answer to that is clearly yes. Okay. So I guess that's it. I don't see more questions coming. Let's hope at 2:45 when we come back, all of this is resolved and we go forward, and we will get a chance to listen to the redacted final version of the interview with Carmen Larber and O'Driscoll that's being admitted by the state to rehabilitate Carmen Lauber by showing that she had made prior consistent statements. We'll all get a chance to hear that. And I will add one thing. You heard the state say they're not going to admit this as an exhibit. It's just publishing for the jury. What that means is the jury is going to hear it in order to give it a better idea of what's going on, to organize, to understand better, but it's not an exhibit. So it's not substantive evidence. That's typically what an exhibit is. Okay, I don't see any other questions. Have a nice long break. They could have, for our purposes, started later. We could have slept longer, but if they started later, they still would have needed a long break, so we would have been in the same place. So ciao a tutti, and ciao for those of you from STS that are on here, and we'll all get back at 2:45 Eastern Time. Bye.